Hello everybody, my name is Stuart Bird and I'm a senior caseworker on the civil finance team based in our Liverpool office. I've been with the LAA since 2010 and I work across a wide variety of billing areas. I also work on the Civil Claim Fix service, which deals with rejection issues. And we're going to start with number 10, which is interim bill not applicable. This is covered at slides 6 and 7 of your slide pack. Interim bills can be submitted where you are requesting the recoupment of a POA. There have been multiple aspects on a family fixed fee case. There has been a change of solicitor in family cases, and one claim or more does not escape the fixed fee. Any interim bill that should be a final bill will be rejected for amendment, and that's where the bulk of the rejections under this rejection category arise. Any interim bill submitted to recoup a POA should also be a note bill, so there will be occasions where rejections will be made if an interim bill to recoup a POA also has a claim for costs on it. For any case with hourly rates, be that non-family or family proceedings, the LEA will treat the claims as one single claim with one single point of assessment. Claims will not be assessed independently, aside from a limited number of exceptions, which we will discuss shortly. For that reason, in non-family cases, it's less usual for an interim bill to be applicable. This means that, generally speaking, where there's been a change of solicitor, the preferred option is that the final solicitor should submit all of the costs of the case for all firms at the same time by way of one final bill. Interim bills cannot be submitted on non-family matters unless a restriction is added to specifically allow an interim bill. That means we're granting permission for an interim bill to be submitted. So because the general expectation is that an interim bill would not be applicable in non-family matters, CCMS will not offer that option. But we recognise there are circumstances where it will be necessary, so we do have the ability to allow an interim bill, but this needs to be requested. The reason for this is to make sure that the correct point of assessment is applied and it prevents any duplication of costs. The guidance referred to in the slides, which is billing after a provider transfer, explains this further in terms of assessable costs and hourly rates. An example of where an interim bill might be applicable in a non-family case is where there are multiple solicitors instructed and one firm is no longer trading. In such cases, it's likely that each firm would need to submit a bill for their own costs, leading to an interim or multiple interim bills and a final bill in the case. If that scenario was to arise, we would need to allow an interim bill to be submitted, and that could be requested. Most often it's by the way of a billing inquiry where you set out the reasons why it's necessary and request that we add a restriction to allow an interim bill under that certificate. There are also limited circumstances where an interim bill can be accepted in family cases. They include in family cases under the fixed fee schemes where work on a specific aspect has concluded. The most common example there is where you might have non-molestation proceedings and private law children proceedings under one certificate. It's often the case that the non-molestation aspect will conclude prior to the private children proceedings. As it's a fixed fee matter, that can be billed at an interim bill, and then we'd expect the private law children matter to be billed by way of a final bill. So when we talk about aspect, that is an aspect of law, and it would most commonly be broken down into the proceeding type, so private law children, non-molestation, and so on. We would also allow an interim bill in family cases under the fixed fee schemes where there's been a transfer of solicitor and one claim or more has not escaped the fixed fee. So there's various scenarios there, especially under the family proceedings, where we might allow an interim bill. So the guidance referred to earlier, billing after a provider transfer, sets out the various scenarios and when we might expect an interim bill. And there is a link to that guidance within the slides.
My name is Georgina Gammon. I am a senior civil finance caseworker based in our Bristol office, and I've been with the Legal Aid Agency since 2021. Some of the projects that I'm involved with include our internal quality control process and the delivery of caseworker training. The 9th most common reason for rejection is incomplete outcomes. In the majority of cases, CCMS prevents the bill from entering the queue to be assessed until the outcomes have been processed. There are, however, some circumstances where the claim may need to be rejected for outcomes being incomplete. Firstly, it may be that the outcome has been processed. However, at the billing stage, the caseworker notices an award in your client's favour which was not recorded on the outcome. In this situation, the claim will need to be rejected and we will ask for the submission of a new outcome which records details of any award made. If you notice prior to submitting your claim that an award has not been recorded on the outcome, you will need to send a billing inquiry via CCMS first to clear the previous outcome. If the previous outcome is not cleared, CCMS will not pull through any updated information, so we will be unable to update the outcome, which may cause further delay. Without accurate outcomes, we are unable to process the bill. There is a link in the slide pack to the Legal Aid Learning website, which provides more information on recording awards and the outcomes process more generally. Additionally, while CCMS will hold solicitor bills back until the outcome has been processed, it is unable to do so for council bills, and therefore, where the solicitor and council bills need to be reviewed together, but the outcome has not been processed, this can lead to rejection of both the solicitor and council bills. We will endeavour to process the outcome wherever possible in this situation. However, if further information is required, then the bill cannot be paid, and so rejections of both the solicitor and council claims will occur. Therefore, it is advisable to wait for confirmation that the outcome has been processed before liaising with council to arrange for submission of the final bills. This is particularly advisable in cases where there is an award in the client's favour, as the likelihood of requiring further information will be higher in this situation. The 8th most common reason for bills being returned is due to missing court orders to evidence certain types of expert fees. The majority of expert fees do not require a copy of the court order to be provided. However, for drug and alcohol testing, transcription fees and risk assessment experts, a copy of the court order instructing the expert is required. The exception to this is where prior authority has been granted, whereby the court order will not be required unless there is a significant difference between the prior authority granted and what is being claimed within the bill. For drug and alcohol testing, the information required from the court order is the name of the party or the parties to be tested, the substances which testing is to be undertaken for, and the type of testing to be undertaken. We also require the length of any testing period and the apportionment of any costs. A top tip for court orders is to highlight the relevant directions within the order and annotate the invoice with the date of the corresponding order. This really helps caseworkers to match court orders to invoices and helps to avoid any directions being missed. The information required in relation to drug and alcohol testing is laid out in 10.14 of the Civil Finance Electronic Handbook, which is linked in the slide pack. Court orders are also needed when transcription fees are being claimed. This is typically where the court has ordered transcription of a judgment. In this instance, we require a copy of the court order which directs the transcription. If transcription has not been ordered by the court, it is helpful to provide an explanation as to why there is not a court order provided. Another top tip is that if there is an unequal apportionment of costs and no prior authority has been granted, it's helpful to provide a copy of the court order and an explanation on submission, which will help caseworkers understand what has happened on assessment. A court order is also required for a risk assessment expert. To claim the risk assessment expert rate, the court order must confirm that a risk assessment expert is required. Therefore, we should have visibility of the order with the claim. Other factors which should be considered when claiming this rate is evidence that the work undertaken is over and above that requiring independent social worker expertise. For instance, a substantiated criminal allegation which is relevant to the proceedings in the background of the case, or a finding of sexual or other abuse relevant to the case has been made by a court, and the report is specifically required to address the risk posed by the above factors. Another top tip is that if an expert fee or a disbursement is unusual in nature or unusually large, then you may wish to apply for prior authority. Prior authority may also be sought where there is no codified rate for the expert. Full guidance on when to apply for prior authority is laid out in 3.1 of the Guidance on Remuneration of Expert Witnesses. The seventh most common reject reason is regarding court orders for FAS hearings. Court orders have replaced the advocate's attendance form as the standard evidence for FAS hearing fees. The standard recommended wording for FAS recitals is shown in the slide pack. This includes the level of judge, the type of hearing, the number of pages in the bundle to verify any bundle payments, the start and end times of the hearing, including any time for pre-hearing discussions and time for agreeing an order, confirmation as to any adjournment undertaken, such as for lunch, or if none has been taken, verification of that fact, details of any bolt-ons being claimed and the applicable party, and any advocates' meetings associated with the hearing. Using this standard wording ensures all information required to assess the claim is provided in the first instance. Where the court order does not outline all relevant information, please include an attendance note in support. There are also a number of additional FAS fees where we would require a court order. Firstly, advocates' meetings. These can only be claimed in public law proceedings and must be ordered by the court. There is no limit to the number of meetings claimable. However, as the public law outline envisages that there would be 2, we require a court order directing the third and any subsequent meetings. This is based on when they have been claimed rather than in chronological order. So, for instance, if counsel have claimed 2 meetings, regardless of where they fall in proceedings, we would require a court order for any meetings claimed in addition to this. A top tip to avoid reject for this reason is to upload the court order for every meeting claimed in the event counsel has already claimed. Some court orders do stipulate a meeting in advance of every hearing, and provided there is an associated hearing, these will suffice as evidence for any subsequent meetings. As the standard evidence is a court order, we would typically expect to see a court order for all hearings. However, another instance where a court order is imperative is where there has been an early settlement and an early settlement fee is being sought, such as for an issues resolution hearing in public law proceedings that settles the matter, a settlement fee in finance proceedings, and a finding of fact hearing at final hearing rates in private law proceedings.
Reason number 6 is at provider request. This is covered at slide 18 of your pack. At provider request is where you've submitted perhaps an incorrect or incomplete claim and you've asked for the claim to be returned. Reasons for these requests might include items have been missed off, it's been drafted at the incorrect rates, the supporting evidence is not yet available or has not been uploaded in full, or the bill has been submitted under the wrong certificate. So the top tip on this section is, before submitting a claim, consider if there are any expert invoices that you've not yet received, as that is the biggest reason for bills being returned at provider request. The LEA are no longer distinguishing between KPI and non-KPI rejects as of April 2021. So KPI is the reference to your firm's key performance indicators. Contract managers are monitoring all return bills in order that we can hold more effective discussions around performance and support. This ultimately helps speed up payments. This approach has successfully helped us to reduce the rate of bills being returned from around 44% prior to April 2021 to around 14% currently. So that's a big improvement and allows us to pay more cash out to providers at the first time of asking. As all billing rejections can impact upon a firm's KPIs, including those where you've requested that we return the claim, it's recommended that you ensure that your claims are complete and correct as best you can prior to submission. If you've noticed that a document has been missed off and you've recently submitted the bill, it is possible to submit a billing inquiry to ask that we reopen the document request so that further documents or evidence can be uploaded. We can only do so, though, prior to the claim being considered for assessment. So it may be the case that we've already considered the claim for assessment, given that we usually assess bills within 5 to 6 working days currently. But it is possible for us to allow documents to be submitted if that request is made and picked up early enough. Likewise, an adjustment bill can be requested and submitted after payment of the final bill if it comes to light that documents or fees have been omitted. Our fifth reason is council fees do not reconcile with allocated costs. This is covered at slides 20 and 21. Council are generally allocated their own costs limitation on CCMS. The final cost paid to council must match their allocation. The cost allocation is net, so it excludes VAT. For cases under the Family Advocacy Scheme, where you are submitting the final bill, the LAA require the balance of the cost remaining to council to be nil. That's to ensure that there's no further claims from council, and the solicitor claim will be rejected if the remaining balance for council is more than zero. The reason for that is council aren't contracted to the LAA in the same way solicitors are, and with them being instructed by the solicitor, our caseworkers will only know if there are further claims forthcoming from council by way of reference to the cost allocation and the amount paid. So having a remaining cost allocation for council where the balance does not match that allocation indicates to our caseworkers that there are likely further claims forthcoming from council. That's why we ask that the amount paid match council's cost allocation and the balance remaining is zero. You can check the amounts allocated and paid to council via the case cost detail screen, and there's a screenshot of that screen on the relevant slide. You can also check the remaining cost allocated to council prior to submitting your final bill via the case statement of account screen. The total council cost ceiling line also shows the full amount allocated to council, and likewise there's a screenshot again on the relevant slides of what that screen looks like. That screen also confirms whether council has submitted a bill but it's not yet been authorised by us. That's particularly helpful where the solicitor and council are to be processed together, say an example for hourly rate cases. CCMS will not show council recoupments, as CCMS does not have the ability to adjust council payments following a recoupment. We are aware of the issues this can cause and apologise for the inconvenience. The reason for that is recoupments to council payments are done outside of the CCMS environment. So for that reason, it won't factor into any figures within CCMS. CCMS is a case management tool, but does not replace your own case management system. So it is still advisable to record the costings under the certificate, especially with regards to council, because if any recoupments do take place, you'll need to refer to those figures because they won't be reflected in council's payments or cost allocation. There may be cases where you identify that council's fees have been incorrectly claimed, we are sometimes asked if it's responsibility of the solicitor to have these corrected before you submit your final bill. Under the contract, the solicitor is ultimately responsible for all fees claimed on a certificate. So if you identify that council have been paid an incorrect fee, or there's an issue regarding a recoupment, this should be corrected prior to submission of your final bill. So you might need to liaise with council to arrange for this to be amended. Doing so, of course, will be beneficial as it ought to prevent any rejection of the solicitor final bill on the grounds of incorrect council's fees. So there's different scenarios with regards to council's fees and how they ought to be billed and how they impact upon the submission of the solicitor's bill. That largely depends on whether a case is part of a family advocacy scheme, in which we expect council's fees to be settled prior to the submission of the solicitor's final bill, or whether it's a hourly rates matter, and that can include some family matters that are exempt from the fixed fee schemes, or for example where the client is a child. For those hourly rate matters, rather than council's fees being settled prior to submission of the solicitor final bill, as is the case under FAS, we would expect that the council bills and solicitor bills come in together for assessment. So there's various scenarios that can arise, and I would point you to the guidance we have referenced on the slides, which is entitled Provider Billing with Council, as that sets out the various scenarios that we commonly see and how the council fees in that matter should be billed and how this impacts on the solicitor's billing process.
The fourth most common reason for reject is for FAS incorrect hearing unit being claimed. Hearings are calculated on either a unit-based fee for interim hearings and a day rate for final hearings. Interim hearings attract a Unit 1 hearing fee for hearings less than 1 hour, a hearing Unit 2 fee between 1 hour and 2.5 hours, or further multiples of a Unit 2 depending on the length of the hearing. The hearing time is generally recorded from the time that it is listed to start, inclusive of any pre-hearing discussions, to the time the hearing concludes, including any time required to draft the order. Any lunch breaks or overnight adjournments will need to be deducted from the fee. Where an interim hearing occurs over multiple days, the time should be calculated as the total time across each day in order to calculate the applicable fee. A final hearing is paid at a daily rate. This fee is payable for each day of the final hearing, excluding any day set aside for handing down judgment where no advocacy is expected. As the rate is a day rate, an advocate's meeting or a conference fee cannot be claimed on the same day as a final hearing fee. Where FAS is claimed incorrectly, both under and over what is expected, based on the court order, the claim will be returned. The top tip here is to use the rates calculator, which allows you to calculate the applicable hearing units, including a multi-day hearing unit calculator, and is a really handy tool. Another common reason for this rejection reason is where a final hearing fee is claimed in error. A final hearing fee should only be claimed where a hearing has been listed for the final determination of a case or an aspect of the case, and there will generally only be one final hearing fee per aspect. A hearing dealt with under consent, which is not expected to be contested or effective, would not be considered to be a final hearing. If the case concludes at a hearing listed as an interim hearing, such as a directions hearing or a case management hearing, then the applicable fee would be an interim fee, as the final hearing fee is applicable only where the hearing is listed in advance as such. There are, however, some other circumstances where a final hearing fee can be paid. Final hearing fees will apply where an issues resolution hearing held under the public law outline concludes the case. Finding of fact hearings can also be paid as final hearings. These are generally considered to form part of a split final hearing. However, the final hearing fee is applicable even if this is not the case. In some instances, a dispute resolution appointment can be claimed as a final hearing. However, it must meet the usual FAS criteria for a final hearing, as defined in 7.127 of the 2018 Standard Civil Contract. It must have been listed with the intention that a final determination would be made and be expected to be both contested and effective. A final hearing fee is not claimable simply by virtue of the hearing resolving the case. A final hearing fee may also be claimed for a return hearing in domestic abuse proceedings where a final order is made. If the respondent is expected to attend but fails to appear, this would be considered applicable. However, if the client withdraws their application or confirms in advance that they do not intend to contest the application, then a final hearing fee is not applicable and the hearing should be claimed at interim rates. The third most common rejection reason is where disbursement vouchers have not been provided. We require a disbursement voucher for any disbursement in excess of £20, including VAT. This also applies to high-cost case bills. The standard evidence varies depending on the type of disbursement, as it's recognised that for court fees and mileage, a receipt or an invoice will not always readily be available, and therefore we will accept a copy of the ledger for these fees. For public transport fares, such as taxis, trains, or parking, we require a copy of the ticket or receipt, and in the case of train fares, please ensure this includes the class of the fare, as we will only consider second-class fares. For GP fees and police disclosure fees, a copy of a letter confirming payment from the practice or the constabulary, an invoice or a receipt will be required. For experts, we require a copy of the invoice with a breakdown of work, with the exception of drug and alcohol testing, transcription fees, and risk assessment expert fees, where we will also require the court order. If this evidence is not available, there is a list of alternative evidence available in the handbook. Where the standard evidence is not available and alternative evidence is provided, please provide an explanation on submission.
The second most common reason for rejection is disbursement voucher detail insufficient. This is covered at slide number 28. Invoices for experts should be produced by the expert and contain the following details: the expert's name, the specialism of the expert, the address of the expert, if they are claiming travel, why they are claiming travel, and where they are travelling to and from. The client's name should also be on the invoice, and we require a breakdown of the work undertaken. So that should give a brief description of the work that expert has done, as well as the hourly rate and the time spent, all sufficient detail to allow us to determine the applicable hourly rate. If the expert's invoice does not contain these details, you will need to request an amended invoice or email confirmation from the expert of the information that is deemed to be missing. If the amount you are claiming is less than the amount on the invoice or disbursement voucher, this should be clearly referenced in the bill narrative, or you could simply amend the document by hand if you wish. An example of where this might be appropriate is if an expert fee has been apportioned, but the apportionment isn't detailed on the expert's invoice, they've just invoiced the whole amount. If you are only paying a share of that fee, then we'd recommend that the invoice be annotated to show that there was an apportionment and the net fee as well as the VAT that you are claiming from the fund. Likewise, as detailed at the top tip here, if the expert invoice does not contain details of the travel claimed, then please try to provide the full details in the bill narrative, or as previously mentioned, we are happy for the invoice or the evidence to be annotated by hand to give us the details of that travel. We ask that you ensure that the actual location travelled from is provided, and that can just be the postcode, as the expert does not always travel from the address given in the invoice, for example, perhaps in the letterhead. So this is often the case with process server firms who might be located at one registered address, which is given on the invoice, but actually they may have a number of more local agents dotted throughout the country, and we do find that occasionally a more local agent has been instructed, which is what we would recommend and expect, but the address of the agents used in that case hasn't actually been provided. So then there's a discrepancy between the address given on the invoice and the travel claimed. It's either way too much or way too little. Where we can't work out or explain that discrepancy, then that is often a cause for rejection to try and clarify that point. A further issue that can arise with disbursement evidence and invoices is that they are sometimes dated after the certificate is either discharged or revoked, and we are often asked if this is an issue and how it should be rectified. Generally, it should be clear from the invoice when work was carried out. Where the invoice is dated after the certificate has been discharged or revoked, and it's not clear from the breakdown of work included in the invoice when that work was undertaken, to help avoid any unnecessary delays to payments, it's worth including an explanation, perhaps in your bill narrative or by annotating the evidence to note when the work was undertaken. It may also help in that scenario if there's any uncertainty about that. If you upload a copy of the orders directing the work or a letter of instruction, perhaps even the report if applicable, if the report is not too lengthy. The important point for us on assessment is when the work was undertaken. It's not necessarily an issue if the invoice date is after the discharge or revocation of the certificate. The invoice date isn't particularly relevant. We just need to know when that work was undertaken, if that work was within scope of the funding certificate. One further question we get on disbursements is why, when a payment on account is paid for disbursement, why can that disbursement then be subject for a rejection on a final bill? And why does the evidence have to be uploaded at the POA stage and the billing stage? Can it not be all checked upon submission of the POA? Although the LEA make payments on account and require evidence to be uploaded in support of these, they are not assessable costs. So POAs, payment on accounts, are not a final payment, and they will be recouped at the final assessment stage as per the terms of the contract specifications. There is only one single point of assessment. We don't assess disbursements when claimed as a POA, so we're not looking at the rate charged, whether the time's considered reasonable. The submission of evidence at that stage is a financial stewardship issue. The assessment comes at the billing stage, and that means that issues may be identified on assessment in relation to the final bill. They've not been raised at the POA stage. So for that reason, we do require evidence both at the POA stage and at the billing stage. Number one in our reasons for rejection is solicitor bill premature. So this covers a number of scenarios where we would consider the solicitor bill to have been submitted too early or not in conjunction with other claims under that certificate. So the first such scenario would be where a previous bill. So this primarily arises with fixed fee bills. If the previous provider, in a case where there's been a transfer of solicitor, has a fixed fee claim, that must have been paid before the last acting firm submit their final bill. So that links back to the very first topic of when an interim bill is applicable. And in such a case, an interim bill would be allowed because there's a transfer of solicitor and at least one of the claims is a fixed fee case. For hourly rate bills, including those that have escaped the fixed fee, where it is the case that we allow for separate claims, for example, where there are multiple providers and one provider is no longer trading, it will be necessary for both claims or all claims to be considered in the case. And that goes back to the point that we discussed at the outset about there being one single point of assessment for hourly rate claims. For such claims, we consider all costs and claims under the certificate to be a single claim with one point of assessment, with assessment being undertaken in one exercise. So for that reason, unlike the previous scenario, we would require all bills to be submitted simultaneously so they can be assessed together. Further guidance on submitting claims where there's been a provider transfer can be found on the provider billing after transfer of provider guidance, which is linked in the relevant slides here. And that sets out the various scenarios for family cases, non-family, for fixed fee and hourly rates, and how each type of bill should be submitted. The second scenario we see in this category of the solicitor bill being prematurely submitted is where council and solicitor bills have not been submitted together. And this is probably the most common scenario that we see, and that is a cause for rejection. So when council are making a claim at hourly rates, these claims, the solicitor claim and council claim, must be submitted together at or on around the same time. That also includes submission of the supporting documents, both for the solicitor claim and for council claim. If council has failed to submit their claim or respond to the document request, all claims will need to be rejected. So that is a cause of frustration, especially for the solicitor. If council haven't submitted their bill, or if council haven't submitted their documents, the solicitor claim has come in, we've got all the documentation we need, the solicitor claim will still be rejected, even though the fault, if we want to call it that, lies with council. The reason for that is, firstly, the principle that, as mentioned, under hourly rate cases, all costs and claims under the certificate are considered as one. There is only one point of assessment, so we can't have assessment of bills at different times or different stages. They need to be assessed as one under one exercise. So we need all claims in with the documents, so that can be done. There's also a practical point of if the solicitor final bill is paid and the council bill is rejected, once that solicitor final bill is paid, CCMS then begins the process of closing down the certificate. This would then prevent the submission and payment of any council bills that remain outstanding. So there's a practical point as well as the principle of one single assessment. So the guidance I referred to previously will assist in this, but there is also a specific guidance material which is entitled Provider Billing with Council, which sets out the scenarios and the steps that need to be taken to bill where costs are being claimed in an hourly rate case and there are council fees to be claimed. So that is the Provider Billing with Council document, and there's a link to that within these slides. So in light of that, the top tip mentioned here is that when liaising with chambers to submit council and solicitor bills together, it's recommended that you agree a date when all claims will be submitted and confirm that they will need to upload the documents also, ideally on that day, to prevent any rejections of those bills. So as mentioned, if council's claim is incorrect, both council and solicitor claims will be rejected so that they can be resubmitted together. So as well as council's claim not being submitted or the documents being omitted, we do also find that rejections happen in this scenario where council's claim is submitted. We have the documents, but actually there's an issue with council's claim. Perhaps the rates are incorrect or the enhancement hasn't been justified. Again, as with the other scenarios, Where that happens, council's claim will be rejected, but the solicitor claim will be rejected also for the same reasons that I mentioned. The claims are submitted as a single claim under the certificate with a single point of assessment. And once the final solicitor bill is paid, CCMS then initiates the process of closing down that certificate. So unfortunately, any issues with council's bill will mean that bill's returned along with the solicitor final bill. So for that reason, when checking council's fee note, it can be useful to consider if council applied the correct rates and if enhancement is claimed, whether that's been justified, justification has been given. If not, then hopefully those issues can be rectified prior to submission of the bill without incurring a reject. So that's not mandatory upon the solicitor, of course, but it is advisable if you wish to try and ensure that a rejection is avoided. In terms of a time frame for submission of bills for this scenario in hourly rate matters where we want council and solicitor claims uploaded together, we are sometimes asked if there's a time limit for these claims to be uploaded, and if there's a delay, then how much of an impact will that have? If one claim is submitted, be that the solicitor bill or the council bill, and the documents are uploaded, it will enter our queue for processing. All claims must be fully submitted, including the uploading of supporting documents at the point that the claim is considered for assessment. If the claims are not fully submitted with the documentation, we will need to reject them as discussed so that they can be resubmitted together. So there's no specific time allowance for council to submit their bills to be considered alongside a solicitor's claim, but in practice, it's dependent on our processing dates. So most civil bills currently are processed within 5 to 6 working days. So a gap of a day or two, once the solicitors submitted their final bill, a gap of a day or two for council to upload their bill with their documents should not necessarily cause a problem. However, best practice would be to submit on the same day. So agree a date with Chambers when the bills are going to be uploaded with the documentation, and that is the best way to avoid any reject because one bill or more hasn't been submitted in time.